Boy, so is she going to be responsible for his death? We know there's an altercation, but can prosecutors make the link that what happened caused the death? And there's another component to this. Apparently, the defendant struggled with a drinking problem. And we know the defense team wants to keep it out. The prosecution wants to put it in. Let's talk about this. Let's bring back in our legal eagles, attorneys, Melba Pearson and Randolph Rice. So let me start with a clip here. The Commonwealth of Massachusetts detailing for the court that the defendant's daughter is going to give testimony and recall what she remembers from that date in question, seeing her mother very drunk. Let's take a look.
What I anticipate you'll hear is that Ms. Zoe Savitz will testify that her mother appeared intoxicated and that she knew that from seeing her intoxicated in the past, and will describe her observations of her mother stumbling, having slurred speech, acting erratic, and having crazy eyes.
Okay, so if they can establish she was drunk on the day in question, what does that mean for both sides? Randolph Rice, would you start us off, please?
If I'm a defense attorney, I love this because this gives me a couple of different options for defenses. An intentional inebriation or intoxication could be a possible defense for the lack of intending to cause a battery, which is one of the elements the state must prove that ultimately led to the death of this victim. So I think this might be backfiring on the state for them because the defense could come in and say, hey, she couldn't form what we call the mens rea, the ability to know what she was doing, the intention to cause that battery.
Ooh, I like that. That's a good point, Randolph. Melba, tell me, do me a favor for the sake of our analysis. If you're on the side of the prosecution, how might you refute what the defense will likely do, what Randolph just pointed out for us, try to embrace that? What do you do to counteract that if you're the Commonwealth?
Well, what I'd be curious about is the history of the defendant, not only in terms of alcohol, but was there a history of domestic violence? Because again, is this the first time that she's laid hands on the victim, or has this been an ongoing issue that every time she gets drunk, she becomes abusive towards him? Because remember, domestic violence can happen, anyone can be an abuser and anyone can be a victim or a survivor. So was there a history of that? What was the time frame? Was it that she got drunk once she heard that she was being evicted and deliberately went over to the house in order to confront her ex-husband? That kind of changes the mindset a little bit versus, you know, she was just in her normal, let's say, struggling with her alcoholic addiction state and then ended up, after hearing the news, going to the house. So I think the order of events is going to be important as in the prosecution's case in presenting this.
Yes, important distinction you just pointed out, Melba. Thank you for that. Randolph, let me go back to you on another point. The defense wants to keep out that Ms. McPhee apparently had a habit of putting wine in her water bottles, taking them with her. Apparently it was a daily drinking problem that she struggled with. We've got a clip. You're going to hear some of the arguments made before Judge Cannoni here.
The officer in a report says something about he believes there was wine in the bottles, in the water bottles. They didn't seize them. They didn't test them. There's no indication of what he bases that statement on. The short story is we don't have anything to show that there was, in fact, wine in the water bottles.
The alcohol consumption goes to the credibility of those statements, her state of mind at that time.
Ooh, so what should Judge Cannoni do here? Randolph, what do you think?
Well, the rules of evidence are very specific about what can be admitted in terms of prior bad acts or prior activities of the defendant. But if it shows a pattern of the defendant, it is an exception to the rules of evidence. So the judge may allow this in, but ultimately it's going to be used for credibility, I think. It doesn't really go towards, well, let me take that back. It may go towards her ability, as I said previously, to form that intent to cause that battery. Because remember, they have to prove that obviously a death occurred, that she intended to cause a battery, and that she knew or reasonably would have known that that battery would have caused the death of the victim. So I think it puts some sort of gray area there with having alcohol involved in this as to what she knew would happen that day.
Yeah, great points you're making, both of you. So let's talk a little more. So with this incident, we know that she was upset. We know he was evicting her. She was mad about it. We know they definitely got into it. But in terms of proving she caused the death, Melba, curious to hear your thoughts on that. Do you think the state is going to be able to get there to prove she actually caused her ex to die?
This is not going to be an easy one because, again, the easy ones very rarely go to trial. So there's a lot that the defense can use to basically mitigate, much like Randolph was mentioning earlier. But I think the prosecution still has a good case to be able to move forward with because, again, you have a witness. Granted, it is the daughter, so that does bring other levels of complications in there. But you do have a witness that can conclusively say she pushed him, she slapped him, and after she did those actions, the victim crumpled to the floor. And then the next thing you know, he was no longer with us. So it's a very simple cause and effect. Like, she hit him, she pushed him, and then he was gone. And the medical examiner makes it very clear that it was basically as a result of being hit, he went into cardiac arrest. So it is kind of straightforward. The question would be the mens rea aspect, as we had discussed earlier.
Sure. Professor, thank you for that. Randolph Rice, let me go back to you, please, with a defense strategy question. What are your thoughts? I know this is early, but on the possibility of Defendant McPhee testifying. Do you think this could be a case where it could help her?
Well, I think it's very telling in this case that she's selected to have a bench trial or a judge trial, because when you have good law, you go with a judge trial. When you have good or bad facts, maybe you go with a jury trial. But in this situation, I think that they realize that the facts of this case don't line up with what the law requires, and that's why they chose the judge trial in this situation. So I think if they play it pretty clean here, they try to keep out things that make damage, but the judge is going to see past that, right? The judge is not like a jury. They're not swayed by emotional arguments or grandstanding in the courtroom. So I think if you play it clean here for the defense, you have a really good chance of winning this case.
Randolph, thank you for mentioning that as well, the fact that this is a bench trial before the Honorable Beverly Cannoni. Yes, we all can sometimes make inferences, just on that fact alone, as you said, for why go before the judge, not before a jury. So thank you. And I'm being told we have a live picture. So as we head to break, let's show you a picture of the courtroom. It should look familiar to you. As we mentioned at the start of the segment, this is the courtroom where defendant Karen Reed was tried and will be tried.